Hi, welcome to Talk to SWU Live, and good evening to you. I'm John McGowan, I'm General Secretary of the Social Workers Union, and welcome to another SWU webinar where social workers get the opportunity to ask employment-based questions. And it's great once more to see so many people online, and I can see the attendees once more for tonight on screen. So thank you for giving up your time tonight. I'm hopeful that we'll get through a lot of questions this evening, and do remember that advice offered for this session is as of today's date, which is the 12th of February 2024. The event is being recorded and it will be available to review and share very soon, so you can all watch it back again. Working behind the scenes are the talented Sean, Joanne, Jane and Lisa. I will now take you through some of the housekeeping for this webinar, and please remember to ask any questions in the live chat box, which is to the right of the screen, and the talented folk behind the scenes will make me aware of them to share with the panel. I've got a big screen up there, so I'll be changing screens and trying to give the panelists the questions. My advice is to keep comments brief and really non-identification factors is in any message, just to represent confidentiality. Before I introduce the panel, I just want to emphasise the need to join a trade union. Of course, I'm biased and would always recommend the only specialist social work union, which of course is SWU. And SWU, working with the British Association of Social Workers, is indeed a terrific collaboration for the social work community. We are more than just skilled representation, and do please see the comments box for info on our campaign fund. And have a look at our webpage for recent blogs and activities. Why would you not want to join a specialist union? Now, over to the important people in this webinar, far more important than me. I will ask each panel member to introduce themselves, and I'll start first with you, Laura Sheridan.
Hello there. Yes, as John has just said, I am Laura Sheridan. I am a member of our bias and representation team, one of the trade union officials, and I have worked across the employment and regulatory side of things. Nowadays, I tend to specialise more in the representing members at the regulator, so the 4 regulators across the UK, but I still do a lot of work with the union side of things as well, and the employment law side of things.
Good, thank you, Laura. And last but not least, Lyse, would you like to introduce yourself?
Hi, I'm Lyse Hurd. And like Laura, I've done both employment law and regulatory body work. However, at the moment, I specialize mostly in employment law. So I'm here to answer whatever questions you might have in relation to either employment law or regulatory body, I suppose. So
there you go. Thank you, Lyse and Laura. Let's get this show on the road. And right, as you would expect, we've got an opening question for you. I'll read the question out pretty slowly, and I'm happy to repeat it. And it's the question is, my organisation is going through a restructure of job functions, a change of job descriptions and pay scales, etc. And the employer is looking at the entire organisation under the Green Book, and the Unison is involved in the discussions, but not SWU. Is there anything we should know about this kind of restructure? And is there any advice that the Social Workers Union can provide? So again, it's a job restructure, and under the Green Book, you can maybe enhance what the Green Book is. Other unions are involved, and is anything that we could add to this restructure? So Laura, could I direct the question at you, because you're first on my screen?
Yes, I was going to, I think the big thing for me thinking about that question is around advice that you can get on a restructure within your workplace. Generally speaking, there is normally a restructure process in which there's a consultation that takes place. And whilst most employers have what they describe as recognised unions for the negotiations around those, and the majority of the time it is the bigger unions that are those recognised unions, that doesn't mean that we can't assist and advise, because what I would always say to people is get in touch with us straight away if you are going through a restructure. Because we can talk you through the restructure process. We can have a conversation with you about what that looks like for you. Sometimes that can involve people changing job positions, having to go and work in a different area, for example, geographical area or a slightly different area of work. And all of those things are potentially a change to your terms and conditions. So it's about us having those conversations with you quite early on in terms of us advising you on how to approach consultations, the fact that we support you to kind of feed into those consultations if you want to, and also quite often if there is a restructure and it is impacting on your individual job, normally people will have one-to-one meetings to discuss the impact on yourself, and we are able to attend those meetings and support you with those meetings and ask questions in relation to your job. So restructures happen, they're inevitable. I think anyone who's worked as a social worker has probably been through a number of restructures within local authorities, and often gone full circle where the final restructure ends with you being in the same, the kind of way it worked, how it was when it started. But it does happen. It's not unusual within local authorities, and there are things that we can do to support with that.
Thank you, Laura. Lyse, is there anything you'd like to add to that question?
No, I think Laura covered it pretty well.
Yeah, I would say pretty well. Well done, Laura. We'll give you a good start for that one. So, Lyse, since we've got you on next, then my questions came in. It's from a social work student. So, welcome, social work students. You're always, I don't know why, but you should all sign up to join BASW and SWU. But the question is, I am a social work student and have joined BASW and SWU. I'm in Scotland, and I understand that the Scottish Social Service Council cover my fitness to practice as a student. So what they want to know, if I have concerns in placement, will I be offered advice and representation? So Lyse, if you would mind picking up.
Sure. Normally we don't represent students in placements where there are practice issues that have come up in relation to that placement. It's not the same as an employment situation. You're not being paid. It's not even really like an apprenticeship. So it is a bit different in that respect. So if you have issues in relation to the placement, so if you're failing your placement or something like that, we don't normally represent under those circumstances. Now, if you are employed either with that particular employer, some people are employed and then they're also doing their placement there as well, or even if you're employed somewhere else that is completely unrelated to social work, we will represent you if something comes up at work. So now in relation to the student placement, there are situations where, and there is some case law around issues that come up that might be disability discrimination. So if something like that comes up, then we may have recourse to represent. But the placement itself is not an employment matter per se. So if you have an issue that comes up in your placement, rather than just say, well, they said they won't represent, give us a call, let us know what the circumstances are, because as I said, if there is a disability, there is a chance that there might be some things that we can do to intervene in those situations. Now, in relation to the SSSC, if you are referred to the SSSC either by an employer or by that particular placement, sometimes they will refer matters on to the SSSC, then we can and do represent if you are eligible. So we can represent you if you do get referred on to the SSSC. So just give us a call.
Thank you, Lyse. And Laura, was there anything else you'd like to add to that question?
Just one tiny thing, because I think Lyse has covered most of it, but I think it's interesting that this question is with regards to the SSSC. And I think all of the regulators in the UK, so the SSSC, NISC, the Northern Ireland regulator, and Social Care Wales, the Welsh regulator, regulate students as well, social work students. So if there was a fitness to practice issue, it would be referred there. Social Work England don't regulate students. So what we're seeing historically, in England, social work students were regulated by the General Social Care Council many years ago, and that kind of changed when the HCPC came in. But what we are seeing is that universities in the UK, in England, are almost carrying out their own fitness to practice processes internally, which it makes it a little bit more difficult in terms of representation. But I would say, again, as Lyse said, ring and talk to us about that, because if there's a fitness to practice issue, you need advice and support with that. And it just does work slightly differently in England in comparison to the other nations. But we are happy to kind of offer advice with that process. So I would say, reiterate, just get in touch if there is any inclination of a fitness practice issue being progressed.
Thank you, Laura, for adding to that. And again, if there's any questions that come in, could you please directly in the process in the box, and they'll come to me. I'm reading off the big screen here, so I'll go to the next question here. So the next question, Laura, if you don't mind answering that. There was a couple of questions in around no, it wasn't secondment. I'll come to that later on. This one's about secondment. So Laura, it's what are your rights with regards to a secondment for your development? My manager stopped my application as there was no backfill for my post. Another staff member has been on secondment now for 18 months, but not due back until September. So she said, I can't go on secondment too. I was shortlisted for interview and I had to withdraw my application. It was for a team manager 12-month secondment, and I'm a senior social work practitioner. So again, the questions around about what are your rights with regards to secondment for your development, and do you have any rights? So Laura, over to you if you can.
Yeah, thank you. It's a reasonably simple one in terms of there is no legal right to be offered a secondment within your employment. There is no kind of law around that. There's no legal duty on the employer to ensure that you can have the secondment if one becomes available. And there will be resource issues that management think about in terms of whether or not they release someone for a secondment. So in a nutshell, in terms of your legal rights, there aren't really any. What I would say is that actually I think it's worth getting hold of your organisation's secondment policy to see if there is anything in there that would indicate what they are supposed to do in terms of their secondment, if they are supposed to offer staff members secondment after a while of employment, etc. Sometimes there is something in the policy. A lot of the time it will say that managers can refuse secondment for business need, for example, if they need you to be working there. I suppose the other thing I would say is, which links into what Lyse was saying in a previous answer, if there's any suggestion that the refusal to go on a secondment could be discriminatory, I would definitely think it's worth exploring and 100% discuss it with us more. So if, for example, you were a female social worker and you'd noted that the male social workers were all being offered out on these secondments and off they went, and that was enhancing their career progression, and the female social workers weren't, potentially there is a discriminatory issue there, and there are methods of challenging that under the Equality Act. So there are some areas you could look at in terms of enforcing people's rights for a secondment, but if it is literally just basically because the manager can't release you, the rights to challenge that are fairly limited, I would say.
Thank you, Laura. Anything you'd like to add to that, Lyse?
Just to say that if anything does come up in your secondment, sometimes you do get another contract specifically for the secondment. So always refer back to that contract to see what the contract actually says itself in relation to the secondment. And if you do struggle with interpreting or understanding the contract, obviously you can send a copy of that to us. And if we can either sometimes look at it and say, okay, here's what this means. Sometimes we can send it on to our solicitors as well to see if there's any comments that they would want to make about it. So it's always worth getting in touch.
Thank you, Lyse. And just to show we're live, thanks for the question that's came in regarding the caseloads. I'll add that to the list, and we'll hopefully we'll come to that fairly soon. So thank you, and any other questions, please bring them in. So Lyse, since we've got you there, it's a nice short question. Really, it's an important question, I would argue as well. Is there any legal protection for people who experience the menopause? So over to you, Lyse, if you can answer that.
Sure, yeah. This is one we get quite a lot in A&R when we're working on duty. The menopause itself is not a protected characteristic, and it is not protected in law per se. However, the case law in relation to menopause is slowly beginning to develop. There have been a number of cases that we and our solicitors are keeping an eye on. So watch this space. And as John said earlier, the information we're giving now is accurate as of today. So if you're watching this anytime after the 12th of February, please either call us or look on our website to get updated information, because as I say, it is changing. There are potential disability discrimination or gender discrimination issues in relation to the menopause. So it's not one of those things that's a non-starter. Where there have been issues raised in the past, it's usually under disability discrimination. For it to be a disability, it would have to have been going on for a year or more, and for it to affect both your personal and your professional life. There could be issues about gender discrimination in relation to menopause for all sorts of reasons. So it's best if you call us if you are experiencing issues at work that relate to menopause. We also have guide sheets that are quite thorough in relation to the menopause. And there is also some advice on our website as well as on the internet in relation to what employers can do to assist you and support you if you are experiencing the menopause and any symptoms in relation to the menopause. So always, we can point you to some of those things, or you can try and find some of that for yourself.
Thank you, Lyse. And Laura, anything you'd like to add to that important question?
Just one brief thing in terms of what we are seeing is an increasing number of employers that are developing menopause policies in their workplace. I think the more awareness that is being raised on this issue and how it could affect people in the workplace, the more employers seem to be kind of getting on board with that, really. I've represented a few members that have asked about whether there's a menopause policy, and it turns out there is one. So some employers are perhaps not as proactive as promoting those policies as there should be, but when asked, there is one in place. So it's definitely worth trying to find out if your employer does have a menopause policy, if it is something that's impacting on you.
Perfect. And I think you're right. I think it's about the awareness as well, especially for men in the workplace as well, that I think that education factor is part of that as well, isn't it? So sharing the policies, for everyone to understand. So thanks for that. And Laura, I think if we can come to you now, I'm just going to summarize this question. I'm going to read it off the screen. So I'm a social worker currently on sick leave, awaiting surgery for a long-term condition. Both my GP and OHLB, Occupational Health person, have recommended part-time working, no longer than 20 hours a week until the surgery has been concluded. Despite having free meetings to try to facilitate a back-to-work plan, the employer has flatly refused to consider the part-time working request. The employer's managing attendance policy clearly states that part-time working can be facilitated on a temporary basis. I feel discriminated against and wondered what my options are. So sick leave, you've got the part-time aspect and the GP's recommendation. So Laura, if you're happy to answer that, I'm happy to go over the question again.
Thank you. I think I got most of it. I'm going to try and break it down into chunks because I think that might be helpful, because the big thing that kind of screamed out at me in that question is the fact that the person said they had a long-term condition. And I think Lyse obviously spoke about that in a previous question in terms of what would be classed as a disability under the Equality Act. Now, that would be a condition that lasts for, is likely to last for 12 months or has lasted for 12 months or longer and has a substantial impact on your day-to-day life. From what's that comment in the question, I would make the presumption that it's possible that this condition, whatever it is, could fall under the definition of disability under the Equality Act. And until we would need to explore that further with a person to actually establish whether that would be the case. Because if it was going to be a long-term condition for a few months, that's wouldn't necessarily mean it met that definition. But I mean, if a person does have a disability under the Equality Act, then the employer has a duty under the Equality Act to make what is called or referred to as reasonable adjustments. And in this case, the flat refusal to what it appears to be even consider making those adjustments, I would say is potentially a failure on the part of the employer to do what they should be doing under the Equality Act. Now, obviously, this is all kind of hypothetical based on what I know, and we would need to explore this in far more detail with the member to establish whether or not there's a disability and what has been said, because employers can refuse flexible working requests, but they have to provide a reason for doing so. And they have to show that they've reasonably considered it. And a simple, no, we're not going to facilitate that, isn't reasonably considering anything. I think also there's reference to policy in there. I would say to any member, get hold of all the relevant policies. So there's always a sickness absence policy. I've yet to find an employer that doesn't have a sickness absence policy. There are also sometimes advice policies on supporting employees with health conditions in the workplace, supporting those with disabilities, or it might be covered in the policy. So I would say get hold of that. If there has been a decision not to offer flexible working, you can appeal that decision. Also, potentially, you could raise a grievance about the discrimination. But I would say to somebody, talk to us about that sooner rather than later, because if there is a discrimination element, it needs to be dealt with sooner rather than later, because there are legal time limits if there is discrimination involved. And also, the sooner we can support somebody in the workplace, the sooner they can get back to being at work and doing what they want to be doing. So absolutely get in touch with us so we could explore all of the potential issues that I've spoken about in more detail, but you definitely have the rights to make those requests and to appeal and decisions if they've been unreasonable in denying those requests.
Thanks, Laura. And Lisa, is there anything you want to add to that? Anything you?
Yeah, just to re-emphasize what Laura just said there in terms of legal time limits, because one of the things that it can be important here is that even though this may be an ongoing issue where you have your employer continuously not providing these reasonable adjustments, it's important to understand that your time starts and the court will consider your time to have started when you either knew or even ought to have known that your employer was not going to provide those reasonable adjustments. And the more minor the adjustment, the more that it's going to, the court will think, well, after a couple of weeks or after a month, you should have known your employer wasn't going to provide that reasonable adjustment. Now, obviously, if it was something like, providing a lift in a building where there never has been a lift, there may be a bit more time to consider, well, maybe you ought to have known within sort of 5-6 months. But it's better to contact us sooner rather than waiting and letting something continue to drift. And you may feel as though and we've written articles about this before in the past, because time and time again, we've had people contact us when really it's too late for us to act on this in any kind of legal sort of way. All we can do is maybe file a grievance, challenge it with your employer. And sometimes when your employer knows that you don't have anything legal to hold, against them in the background, for a lack of a better way of putting that, they may just think, well, there's nothing you can do to us now about this anyway. So please contact us. We would rather you contact us and us have to say, oh, well, no, it's fine, you don't need to have contacted us now, than for you to contact us when it's too late and for us to have to kind of disappoint you in saying, look, there's not much we can do about this now.
Thank you, Lisa. And if anybody's listening in who's not, I don't know why you would not, but if you've not joined BASW and SWU, and you would make contact through a duty appointment, so any member can, after a qualifying time, can contact the duty team, and that's where you would get allocated to a skillful A&R officer to answer the queries that we're talking about. So just to let you know that. And if you're not a member, then you can obviously sign up and look forward to welcoming you. So the next part then, we'll keep you there, Lyse. It's moving on from the sick period one. This one is about quite an interesting one, actually. My employer has barred me from working, engaging and or associating with another employer who is also a friend. There must be another employee after constructive dismissal for any period following discrimination issues. So the person wants to know if that's correct or any advice.
Yeah, this is an interesting one. Now, I sort of took that as what the person meant, and I may have gotten this wrong, but I took this as what the person meant by employer was that they had a friend who maybe worked somewhere else, for instance. So I'll kind of cover it on both of those bases, and hopefully I will have answered the question. but under some contractual provisions, your employer can, prevent you from working at another similar place of work or from associating with a similar type of employer. This is done in circumstances where there may be a no-compete clause in place, a no-compete clause in place. So, for instance, if you're working for a fostering agency, and fostering agencies seem to be the types of organizations this comes up, or even care homes, that sort of thing, your employer may prevent you from working for another fostering agency for a period of time. And that's to keep you from bringing all of their foster carers over, or maybe even, people who are placing children at those particular foster carers over to another agency. So that's why they call it a no-compete clause. Now, if you have a friend, for instance, who is working either for that same employer that you just left or for a competing organization, for instance, they cannot prevent you speaking to friends or associating with your friends. They just can't. In these circumstances, if there is something that could, mean that you would breach, for instance, GDPR, or you would breach that no compete clause, then you just need to be very careful as to how the things you speak to that friend about. But in terms of now, the other thing that's come up for us in the past, and I'll go ahead and address this to make sure I've covered this question, is that, for instance, if you've been suspended, your employer, and say your best friend works for the same organization, your employer cannot prevent you from speaking to your best friend. What they can prevent you doing is speaking to your best friend about your suspension, about the thing that led to your suspension, that sort of thing. But, and there is actually some case law about this, is that, these are your support systems, so they can't stop you from accessing your support. What I would recommend is that if there is a situation like that, best to be transparent. Look, my best friend, works in adults and I work in children's, or, Mary is my best friend and I will be speaking to Mary on a regular basis. And the other thing that it would be important is if we're representing you in a situation where this comes up, let us know and we can challenge it on your behalf. So hopefully I've covered that question, and I don't know, I know John is likely to call in Laura, but Laura may have some other things to add to what I've just said in relation to this.
Thank you, Lisa. And Laura, over to you. Anything to add to that question?
I think Lisa's covered it perfectly fine. I don't really need to add anything to that one. Thank you.
Thank you. So we've still got some time. In fact, believe it or not, we're halfway through this session and we've answered so many questions. So keep them coming in. We have got room for a few more. Another live one's came in, and it's regarding an employer reporting someone for DBS issues. And just want to say that we don't offer advice on representation with DBS issues. So it's really limited what we could do here at A&R. There's an organisation called NACRO, I think, who deals with that. Just to let you know, we won't be answering that, just so you don't think I'm ignoring the question. You can speak to an advisor on DBS issues at NACRO, and the information you could probably find on their website. So sorry about that. We'll move on from the employer ban from work and engaging question. So I've got one on whistleblowing next, Laura. If you don't mind, we'll move to whistleblowing. The person says, whistleblowing, what sort of statements are protected? What is the right way to go about making a protected disclosure, and can I go to the press directly?
Yeah, thank you, John. This is it's an interesting one because it's quite it's a specific area of law around whistleblowing. The legal term for whistleblowing is what's called a protected disclosure, basically. So if you make a whistleblowing complaint, as it's more widely known, it's what's known as a protected disclosure under legislation. Now, a protected disclosure is something where a staff member would be raising very serious concerns that are in the public interest to be raised with their employer. So examples of that under the legislation, they give specifics. One of those would be a failure to follow any legal duty, Other things are issues around health and safety, for example. It's got to be something that it would be in the public interest to be raised and to be investigated by the employer. Normally there is a whistleblowing policy, an employer should have one, and we always recommend to people that you look at that policy and you follow that policy in terms of how you make a whistleblowing complaint. Not everything counts as whistleblowing. Raising a grievance about something isn't necessarily a whistleblowing complaint. And like I say, the law is quite specific about what is and isn't counted as whistleblowing. But if you do make a complaint under the whistleblowing procedure, and examples of that would be concerns about the failure to follow a legal duty would be a failure on the employer's part to be following proper safeguarding processes. If someone's got really serious concerns that safeguarding processes aren't being followed, or a key example in the medical world is if medication errors are repeatedly happening because of shortages of staff, that kind of thing. They're the kind of things that would be potentially raised under whistleblowing. If you raise it under the whistleblowing policy, employees are legally protected by whistleblowing legislation, and it basically has the effect of you shouldn't suffer a detriment. It's illegal for you to suffer a detriment as a result of having blown the whistle. So if you raise a concern, a whistleblowing concern, and then a week later you find that perhaps there's been concerns raised about your practice, or suddenly you're under a disciplinary for something, if you've recently raised a whistleblowing concern, that would raise questions, I think. And so again, I would say to people, get in touch to discuss whistleblowing, but I think get in touch if you have found that you have blown the whistle, and then you've suffered a detriment as a result. Because we do see it happen, and of course social workers have a duty under their professional standards, as they're known at social working, or codes of conduct, depending on which regulator you're under. They're referred to different things, but there's clear, all of those duties are around a professional duty to report risks of harm to service users. So if you are concerned, you should be blowing the whistle on that, but obviously if there are detriments following that, it is unlawful, and we need to advise you and support you with how to challenge that, really.
Thank you, Laura. What a well extended answer. I enjoyed that one. And Lyse, is anything else you'd like to add to that?
Yeah, I mean, just to make sure that you're not doing things like going to the press, because we have had that happen in the past before. That's not really the way to handle these things, and you may not be legally protected if you take that route right out of the starting gate. Likewise, as Laura said, please follow your local policies. Make sure you're crossing your T's and dotting your I's in relation to this. That way you are protected. And if you are in any kind of doubt about an approach to take, then by all means give us a call and we can talk you through that.
Thank you, Lyse. So that was a good question there. Whistleblowing, we've got another 3, 4, 5 questions I think in at the moment, so we're still doing well for time. And this one, Lyse, since Laura answered the whistleblowing, this one, I'll just read this one out to you. Does an employer have to complete a disciplinary or grievance investigation within a certain timescale? So is it a timescale for an investigation to be completed?
Unfortunately, there isn't. We've had disciplinaries and grievances and things like that have gone on for not only months but years, and it's the ACAS guidance basically just says a reasonable amount of time, and my idea of a reasonable amount of time might be different than yours or your employers or anyone like that. Now, if this does go to court, so for instance, if you're under disciplinary and you get you take them to court for instance, maybe an unfair dismissal, if the court rules in your favor, then if they've taken, say, 3.5 years to complete a disciplinary process, the court may decide to give a 25% increase in any kind of money that you get in relation to that. But in terms of now, the other thing again, and you'll hear us preach this quite a lot, is going to that local policy. In my experience, most policies, and I don't know if Laura's ever come across one herself, but in my experience, most policies don't say, oh, well, you know, this has to be done within this amount of time. Now, sometimes grievances will say things like, well, within 5 days, we have to do this, and 20 days, we have to do that. Most of the time, that's just about acknowledging your grievance. So within 5 days, we have to say, hey, we've got your grievance, we're going to deal with it. And then if they've done that, then they've done their obligation in relation to that. But I don't think I've ever come across a situation where a local policy will say we have to have this completed, this disciplinary completed within, say, 6 months of time. If there is a situation where the employer is, you know, particularly anxious about an employee, whether it's a genuine, you know, concern about their ability to do the job, or in some cases it's you know, your face doesn't fit, so they want rid, then sometimes they'll speed you through that process, which can be just as disconcerting sometimes as them taking months and months to do it. But again, you know, if you are in any doubt, and if it does need to be challenged, obviously we will challenge that and quite robustly challenge it. Sometimes if you're going through a disciplinary and it's taking months and months, you can file a grievance about that. And in some cases, if the grievance is heard from a different department than the one where you're working, it could end up going in your favor, and whoever's dealing with your disciplinary could be told off or what have you. But unfortunately, you know, if there isn't anything set in law that says all grievances have to be dealt with within 6 months, or all disciplinaries have to be dealt with within 6 months, or whatever time period.
Thank you, Lyse. And Laura, would you like to, anything you would like to add to the timescales?
Just one observation, and that is I genuinely wish there were timescales, because it would make it a lot easier for us to challenge employers. We do challenge employers, but you can't say, well, you're breaking the law, because they're not breaking the law. And I think even when you come down to policies, which Lisa touched on in her answer, occasionally, and it is very occasionally, you do get employers that will put, we aim to have this this disciplinary process completed within a certain amount of time. I think I've seen it once in the time I've been working at BASW and SWU, and I've been here for 5.5 years now, so it's not common. Having said that, what you normally see with those policies is they will start off by specifying, or the person's contract will, or something will specify that this policy isn't part of somebody's contract. It's not a contractual thing. So even that doesn't really give you, you can say, well, you're not meeting your policy, and you can challenge it, but it doesn't give you that legal redress even with that most of the time, because they've clearly said this isn't part of your contract. So when they're not breaching your employment contract by going over their policy, it gives us more scope to challenge things, and that's what we do. We challenge things, but the law is quite lacking in that area, I would say, and it is a continual source of frustration for us.
Thank you, Laura. I bet you wish that was the same timescales for regulatory work as well.
Well, there's no timescale. There's no timescale for them either, John, and that is a huge bone of contention for all of us.
And for our members as well, who don't forget have to wait.
Yeah. So, absolutely, it's a big thing that we raise regularly with the regulators about the amount of time that is taken for a fitness to practice case from the start to the finish. Has often been extremely excessive, basically, and again, it's something that we challenge regularly as representatives.
Yeah, thank you, Laura. So I'll stay with you for this question. It's I'm an agency worker working for a local authority and using an umbrella company. So am I employed or self-employed? So it would be good to emphasise what umbrella company, and they're asking if they're employed or self-employed. Is that okay, Laura?
Yeah. I mean, ultimately it comes down to what your contract says. The most common arrangement or working arrangement we see with agency workers nowadays is that they are employed by the actual umbrella company. So the umbrella company acts as their employer, and they are responsible for sorting out the kind of tax, national insurance side of things. And you normally have an employment contract with your umbrella company, and then they work with the agency, and the agency kind of place you somewhere. And so the agency aren't normally your employer. Normally, obviously, the end user, as in whichever placement you're at, isn't the employer either, because obviously you're an agency worker. So it's a little bit more complicated than your average, I suppose, employment relationship. But most of the time, what we tend to see is that the umbrella company acts as the employer, and they deal, as I say, with the kind of tax, national insurance side of things, and they pay your salary, wages effectively after dealing with those deductions. But I've seen the odd case where that's not that clear cut, so it really would depend what your contract of employment said, and if you are kind of independent, it's worth getting that checked out with if you quite often people use an accountant, for example, in terms of what that is, but 9 times out of 10 you are employed via an umbrella company.
Thank you, Laura. And Lyse, using your knowledge, anything else you'd like to add?
No, not at the moment. Thank you.
Good. So we've got another question here. So Lyse, I'll direct it to you. So it's I'll read it out. It's, how do you support a colleague when you are aware they are being bullied by a manager? However, when this has been raised to senior managers a number of times, it's swept under the table. So the person's asking how you deal with that.
Yeah. You could potentially file a grievance or a complaint on their behalf. Now, sometimes employers are a bit weird about taking grievances that don't actually have to do with you. So you're complaining about something that's happening to an employee. If your employer tries to do that, one of the things you could always address in the grievance is how that bullying is impacting on you. Because when someone else is being bullied, it's not just the person being bullied who's being impacted by that. So that would be a reason for you to file that grievance. Or if worse came to worse, you could file a complaint. And there are differences between complaints and grievances. A grievance, you have a legal right to a grievance. A complaint is something, that you file that wouldn't necessarily fall within the employer's grievance policy. Now, another thing that you could do is you could escalate the situation within the management structure. Sometimes upper managers don't always know what's going on the ground. Don't always assume that just because Mary Bloggs is a big bully and everybody knows she's a big bully, don't always assume that her manager knows it, or that her manager's manager knows it, or even going so high as going to the director. So you can always escalate things within a management structure. I've even had cases where I've said that I was going to potentially go to members of their council, so the council, the elected members, they don't like it when you do that. So that could be another thing that you could do. And this is potentially a whistleblowing situation, because what you're doing is, especially if it's a situation where someone's being bullied for because of a protected characteristic, so you're potentially looking at whistleblowing as well. Now, another thing that you can always do, but obviously you would want to be very careful about doing this, is that you can always report your concerns if the person is a registered professional, especially if they're a registered social worker. You can always report those concerns. If you've done all of those other things and you've tried to get it dealt with internally, you can always go to that person's regulator. So Social Work England, Social Care Wales, the Northern Ireland Social Services Council, and then the SSSC in Scotland, the Scottish Social Services Council. So you can always escalate those, because quite often those particular regulators will take those things seriously. Now, if you're talking about nurses or doctors, because that does sometimes happen within the NHS if social workers are working within the NHS, it's a bit hit and miss as to whether those regulators take those types of complaints seriously. So you'd really need to make sure you worded that in a way that made them sit up and take notice. But I would definitely encourage you. And if you have colleagues who've also witnessed bullying of a particular member of staff, or of a certain group of staff, or maybe a couple of your other colleagues, and they're willing to put their heads above the parapet, the more people who are making those complaints, the less likely it is the employer is going to be able to ignore those complaints. And again, if you've tried everything that you possibly can think of and you need our assistance, because we do represent during grievances. Now, complaints, not always. We would need to take a look at it to see if it's the type of thing we would be able to represent for. But grievances, definitely, if you've filed a group grievance or if you've filed a grievance as an individual about a particular situation that's going on. But always make sure that you make it clear how it's also impacting you as well as how it's impacting that member of staff. And because you're working for social services, how this kind of behavior could be impacting the people that you are there to serve. Because if someone's being bullied or you're having to witness bullying, it's not going to make you or that person the best social worker that they can possibly be. So it's very clear, it's very important to outline all of those things.
Thank you. And anything you want to add to that one, Laura, before we go to the next question?
No, I think Lisa's covered that very well. Thank you.
Good. So we've got 3 questions left, but just my own interest in anybody listening. What about I just got a question to you, just really about your own job and maybe what you enjoy. I'm just interested in hearing from you. We've covered a lot of questions here. Just anything you particularly enjoy about your role in a busy A&R team?
Well, I would say we've got a really good team, which is great. But also, I think one of the big things I enjoy about the job is when we get a good outcome for our members. I mean, I've worked with some absolutely fantastic members, fantastic social workers in the time that I've worked with BASW. We've been through some really difficult processes, and sometimes some very unjust processes that they should never have been facing. And when you're able to get the best outcome for that member, it does. It is a really nice element of the job. So the kind of work with our members and dealing with the people we deal with it sounds a bit cheesy, I suppose, but it is a really positive part of the job.
Thank you, Laura. I think it's always great to hear from A&R because, to me, it's a unique selling point. And I think even listening to this webinar, just the quality of the answers. So saying that, no pressure, I'll put you on to the next question then, Laura, since you've answered that. And the person's asking, the organisation that I'm currently working for is concerning, according to the person. They've got caseloads are high with 50s to 60s in the caseloads, and senior manager are not supportive of staff. They often ignore staff concerns, and in their opinion, they bring into attention regarding their unethical practice and high caseloads. Just looking for some advice how they might tackle this matter. So Laura, there's quite a lot there, but anything you would share?
There is quite a lot there, and I think it's important to kind of almost give the tactical advice on how to manage that. The first thing I would say is any concerns that you are raising, make sure you are raising them in writing. And make sure you're noting when you're raising them concerns, and you keep a copy of that email where you have raised those concerns. And it's really important that you do that because under the kind of regulated, if you're a regulated professional, which social workers are, you have a duty to raise concerns about employment practices that are making it difficult for you to be able to do your job, basically, and to be able to do your job safely. And caseloads of within the 50s and 60s, I would very strongly argue, make it very difficult for a social worker to effectively carry out their duties as they should be. So I would say definitely make sure any issues you're raising are in writing, and if your colleagues are raising the same issues, do it collectively. You can do that and raise it as an issue. If things don't improve, you have the option of raising a grievance. then you've formalized it basically. And again, if your colleagues are also raising the concerns, you can do a collective grievance, and we can advise you on the contents of that grievance, and we can represent you in grievance meetings. And that just gives a very clear audit trail of the fact that you have done everything you can to raise concerns about the caseloads that you are having, basically. Because if you don't raise the concerns, if you just keep carrying on accepting, you know, the cases as they come your way, and something goes wrong, and I'm talking worst case scenario here, but obviously our team deal with worst case scenarios, you know, the question would be asked by the regulator, well, what did you do as a social worker? You know, if you were concerned about the caseloads, you know, you had a duty to raise it, why didn't you? So actually, it's really important that you make it clear that, you know, you are concerned about the issues, and raise it as a formal grievance if things don't improve. And you know, it's always better in numbers if you can, so discuss it with your colleagues, and see if you can raise a collective grievance. And I mean, I'd say come to us for advice. I'm pretty certain that all of my colleagues would give the same advice as I'm giving now, but make sure you're doing things in writing, and keep a note of what's happening, you know, when you've raised things, who you've raised it with, a chronology of events, because you may need that at some point in the future. But hopefully by raising it as a formal grievance, the organisation are having to consider that. Potentially it's also a whistleblowing issue, because there could be a safeguarding issue there with the caseloads being that high. So look at the whistleblowing policy as well and see if it would be appropriate to raise it as a whistleblowing complaint and or a grievance, because there are all sorts of issues from a safeguarding point of view, from a staff burnout point of view, with caseloads being that high. It's not good, and it has a real potential for something to go wrong.
Thank you, Laura. Anything you'd like to add to that, Lyse?
Yeah, I'm glad Laura mentioned that about the regulator, and we cannot emphasize this enough. Your employer is potentially putting your regulation at risk, because I promise you, and people don't believe us sometimes when we say this, but I promise you, if you go to the regulator and say, I made that mistake because I had too many cases, they're going to say, well, what did you do about that? Now, in a worst case scenario, and I wouldn't use this as a first resort, but in a worst case scenario, you can go to places like Ofsted, the CQC, to report to them if the employer's not taking it seriously. And you can say to your employer, if you don't start taking this seriously, we're not going to have any choice but to inform Ofsted that this is what's happening here. There are recommendations as to what a caseload should look like for social workers. For children's, it's around 16 to 18, and I believe for adults, it's around 25 cases. So it's a lot lower than what I realized it was when I first started doing this type of work. So just always bear that in mind. And grievances, it's about your main recourse is to file grievances about this. It's a really, really serious matter.
Thank you, Lyse. And since I've got you on, I'll ask you another question, but I'm just sort of curious, and hopefully the people listening in as well, just how would you describe a typical day in your A&R team? Is it just full-on questions, or anything you'd like to share as a typical day?
Yeah, I mean, a typical day for A&R is that your day is never typical. You may wake up one morning and you're reading emails all day, answering emails all day, challenging employers, making phone calls. Sometimes, we have situations where, you've got a particularly distressed member that, I'm just going to quit my job, or, I'm quitting social work, and, you're kind of having to talk them through processes, put them at ease. Making sure, no, we're not counselors, obviously, and we would never put ourselves in those roles, but sometimes we can kind of point you towards, maybe if you, speak to these people or speak to those people, you can get some assistance there. And, then you may have days where you're in meetings all day, and you could have a meeting where you sit there and you don't really need to say anything because you've got an employer who's ticking all those boxes that you want for them to tick. But then you may have meetings where you're having to challenge some really, sometimes very bizarre stuff that employers try to get away with our members. And one thing I will say about every single one of my team, there is not a person on my team that I would not want to have sitting beside me if I was ever in trouble at work. I can promise you that. You are going to get people who, you know, their whole bread and butter throughout their whole social work careers has been to challenge, and they are not afraid to do it. None of us. So it's a great job, and I love challenging injustice. And for me, I see myself as protecting the people who are protecting the vulnerable members of our society.
Thank you, Lyse. Now we've got 2 questions left, and that'll be it. We've got 5 minutes, so we're going to squeeze them in. So hopefully you'll stay till the end. Excuse my pronunciation. I will do my best because it's very important. The question is, I'm a social worker with endometriosis. Is there any legal protection? So would you mind answering that, Lisa? I'm happy to expand on that.
Yes, definitely. Endometriosis, very similar, you know, to menopause or any other kind of illness. It's a very serious and can be a very debilitating illness that sometimes people will go through. So, and again, going back to disabilities, if it's something that has gone on for a year or more, or is likely to go on for a year or more. Now, just to be clear, only a court can ultimately determine if something is a disability. Sometimes occupational health will comment on it, but your employer is better off treating it as though it is a disability. And with endometriosis, there are going to be reasonable adjustments that your employer could provide you that would make your life easier at work. And sometimes they don't really cost much. It may be something as simple as, okay, when you're starting to feel pain, for instance, you have our permission to go down and, you know, go lay down, take a nap for a couple of hours, if that's what helps you. So, and we have what's called a reasonable adjustment passport that we use. Your employer may have one themselves. Now, don't think that you have to have, you know, what we all typically think of as disabilities in order to use those reasonable adjustment passports. And you don't even have to have a disability to use them. So if your employer does have one, or if they don't, access the one from our website, fill that thing out and set it in front of your line manager and say, okay, I want to go over this. This is what's going to make me stay at work. And that's what you have to remember, is that these things are done to prevent sickness absence. And again, if you're struggling with that, or your employer is just not listening, give us a call.
Thank you, Lyse. The next one is, need to be direct with this one, but it's an important question. So it's, due to my workplace not having a fully functional grievance process, do I have a right to go straight to the employment tribunal? What grounds do I have, as I've tried to follow workplace processes, but the system is flawed? Laura, we've got a couple of minutes on that one. So
that would depend on what you are wanting to go to an employment tribunal for, because obviously I don't know what you're raising the grievance about. There is no the employer doesn't legally have to have a grievance process in place. They should, and it wouldn't look, if you were to go to tribunal, they would potentially look at, well, they didn't follow a grievance process, so then you may have an increase in compensation, but you need to have an actual tribunal claim to be able to. You couldn't go to an employment tribunal for an employer's failure to follow a grievance process, because that's not an employment tribunal claim. So in a nutshell, we would really need to know what the actual grievance was about in order to advise whether or not it would be something that you could go to an employment tribunal with in the first place.
thank you, Laura. As direct as ever. You've got a minute, Lisa, if you'd like to add anything to strengthen that.
No, I think Laura covered that one really well.
Perfect. So as we've listened to 2 experienced, Lisa and Laura from the A&R team, a small part of the team along with colleagues. So please do, hopefully it doesn't happen, but if you need it, please do consider calling duty. I've been John McGowan, and this has been Talk to SWU. Thanks again, and good night, everyone.